How's it going, everybody? Today I have an open discussion presenting the Family Court Evidence Integrity and Protective Order Accountability Act. My name is Todd Houseconnect. I want to have a serious, reasonable, and necessary discussion about family court reform in Pennsylvania. I don't have a teleprompter, so I'm reading my script off of my phone. This is not about attacking judges. This is not about attacking attorneys. This is not about attacking victims, parents, or anyone who uses the court system in good faith. This is about protecting the integrity of the system itself. Because when a system has the power to separate parents from children, enforce protective orders, restrict communication, impose support obligations, punish contempt, and make decisions that can alter the entire future of a family, that system must operate with the highest level of fairness, evidence integrity, and due process. What I am presenting today is a reform package called the Family Court Evidence Integrity and Protective Order Accountability Act. The purpose of this proposal is simple. Pennsylvania needs a clear, neutral, lawful safety valve for family court cases involving protective orders, custody, contempt, court-ordered communications app, digital evidence, alleged false reporting, parental alienation, attorney misconduct concerns, judicial conflict concerns, and situations where a party believes material evidence was ignored before a life-changing order was even entered. This reform is not designed to reverse court orders. It is not designed to replace appeals. It is not designed to punish anyone based on accusations alone. It is designed to create a practical accountability channel that protects everybody: abuse victims, children, accused parties, parents, self-represented litigants, judges, attorneys, and the public's trust in our court systems. Because no person should walk into a courtroom believing that the evidence does not matter. No parent should lose meaningful access to their children without a fair hearing. And no protective order should be treated like a piece of paper with absolutely no enforcement behind it. No digital evidence from a court-ordered communication app should be ignored simply because one party does not know how to properly submit it. And no self-represented litigant should be overwhelmed by procedure to the point where due process becomes theoretical instead of a real thing. I want to be very clear about something. This proposal is not anti-court, it's pro-court integrity. A strong court system should welcome procedures that make the record cleaner, the process clearer, and the outcomes more defensible. If a judge makes a ruling after hearing all relevant evidence, that ruling is a stronger ruling. If an attorney acts ethically and within the rules, this process protects the attorney from false accusations. If a person truly needs protection from abuse, this process helps preserve the evidence needed to enforce that protection. If a person is being falsely accused of something, this process helps preserve the evidence needed to expose that as well. This bill is about truth, process, safety, and accountability. True transparency. One of the major issues with this reform addresses is digital evidence. We live in a world where some of the most important evidence in a family court case may not always be on paper. It may be in text messages, it may be in videos, it may be in voice recordings, it may even be in emails. It may be in police reports, screenshots, app records, or messages from a court-ordered communication platform like AppClose and our Family Wizard. When a court orders parties to communicate through a specific app, there should be no confusion about whether those communications are how those communications are preserved, how they can be exported, how they can be submitted, and whether the court will review them when they are relevant to contempt, custody, PFA compliance, child safety, and even parental alienation. If a court tells somebody, use this app, then the court system should also provide clear rules for how evidence from that app is handled. This is why this bill proposes a digital evidence index. Now, the digital evidence index would be a simple form. It would not automatically make the evidence admissible. It would not force a judge to accept every single screenshot or every recording, but it would create a clear record of what evidence a party is trying to present. The form would identify the types of evidence, the date, the platform, the parties involved, why it matters, and whether the party is asking for preservation, review, admission, or authentication assistance. This does help everybody in the long run. It helps self-represented litigants because they have a clear way to organize their evidence. It helps judges because they are not being handed a messy pile of screenshots with absolutely no context behind them. It helps attorneys because it narrows the issue. It helps appellate review because there is a clearer record at hand. And it helps protect children and abuse victims because important evidence is less likely to disappear, be buried, and be ignored. Another major part of this proposal is court-ordered communication app preservation. When a court orders parties to communicate through a certain app, the order should say exactly what that means. Does the app preserve records? Can records be exported? Who can request them? How are they submitted? Are parties prohibited from deleting or altering messages? What happens if someone manipulates the record? These are basic questions that I think are very, very relevant in any case, but they do matter. A parent cannot be told to use a court-appointed communication channel and then later be left guessing how to get that evidence in front of the court when the evidence is crucial. The next part of this reform concerns dual hearings and notice safeguards. In family court, multiple issues are often scheduled close together, sometimes even on the same day. One hearing may involve contempt, another may involve custody, another may involve support, another may involve a PFA matter. These issues sometimes overlap, but they are not always the same thing. If a parent appears for one type of hearing, they should know exactly what is being decided that day. If custody is going to be changed, that should be clearly noticed. If a parental contact is going to be restricted, the parties should know that before they walk into a courtroom, not after the fact, not when somebody's mad, not after accountability is held, that day. If support, contempt, or PFA enforcement is being addressed, the court should clearly identify what issues are on the table. This proposal says that no order substantially reduces a parent's custody, visitation, or communication with the child should be entered at a hearing notice only for another purpose unless there is an emergency risk, clear notice, or an expedited full hearing after the fact. This does not stop courts from protecting children in an emergency. If there is an immediate danger, the court must be able to act. But emergency action should be followed by a meaningful hearing where evidence can be presented, challenged, and reviewed. That's due process. Due process does not always mean one side always wins. Due process means both sides are heard before life-changing decisions are made. Not one side gets to talk, they're represented by the attorney, and the other one's silenced and overheard and ignored because they're pro se litigant, and nobody wants to listen to anything that person has to say because they're unfamiliar with the process. But their statements and testimony are very relevant to the subject matter at hand. The next issue is PFA enforcement accountability. Protection from abuse orders are serious. They should protect people. They should also be enforced. If a PFA order is being violated, there should be a clear process for reporting that violation, preserving evidence, and bringing the issue before the courts. Because sometimes the police don't always want to get involved. They're tired of repeat callers. They're tired of repeat offenders. At some point, they just go numb to the entire situation. Then one party's affected, the other's getting away with it, no accountability is had, and zero enforcement is taking place. That's a problem. This process also has to protect against misuse, though. A PFA should not be weaponized as a tool for harassment, custody leverage, retaliation, or false allegations. At the same time, real victims must never be discouraged from seeking protection because the process is either too confusing or rather inconsistent. That is why this bill asks for each county to have clear written processes for PFA violation reporting. The process should explain how violations are reported, how digital evidence is submitted, how repeat violations are tracked, and how both parties are informed of their rights. Basically, the county is keeping a timeline record of accountability on each individual case, building a long-term picture, so if somebody's a habitual offender, they can reflect on that timeline and, okay, well, this is obviously a perpetual pattern, so we know now how to change the gravity score and charge them accordingly. Now, the goal is not to favor one side. The goal is to make enforcement consistent and evidence-based. Another important section is the attorney candor and false evidence referral procedure. Attorneys have a duty to advocate for their clients, but advocacy does have its limits. A lawyer should not knowingly present false evidence. A lawyer should not knowingly rely on perjury. A lawyer should not assist a client in using the court system for fraud, harassment, or abuse. At the same time, an attorney should not be disqualified just because the opposing party is angry or makes an accusation. That is why this bill creates a balanced process here for both sides. If a party believes an attorney knowingly presented or failed to correct false material evidence, that allegation must be specific. The party must identify the contradictory evidence. The court can then decide whether the issue affects the pending case, whether the counsel may be a necessary witness, whether disqualification or withdrawal should be considered, or whether the issue should be referred to the Office of Disciplinary Counsel. This protects the public from attorney misconduct while also protecting attorneys from reckless accusations. The next issue here is judicial conflict and appearance of impropriety review. Public trust in the judiciary depends not only on actual fairness, but also on the appearance of fairness. If a party has a good faith concern that a judge has a conflict, a connection, a relationship, personal knowledge, or some other circumstance that could potentially cause a reasonable person to question impartiality, there should be a clear process to raise that issue respectfully. This bill would allow a party to file a verified conflict or appearance review notice, and then that notice would have to identify the concern and attach supporting evidence where available. A judge could respond on the record, disclose relevant information, deny the request, recuse, or refer the matter to the president judge for administrative review. This is not about forcing recusals based on rumors. It is about creating transparency, and transparency here is key because we are seriously lacking transparency in family court systems in these modern times. If there is no conflict, the record can reflect that. But if there is a conflict, it can be handled before the case is damaged. Like I touched on my protective communications framework, it is isolating a problem so the entire mechanics of the system itself isn't impacted. It is minimalizing casualties, sectioning it off, and offering a real solution to a problem before it expands to a out-of-control issue that is just the entire county liable at some point. Now, the next section is very important. Self-represented litigants, due process safeguards. A lot of people in family courts do not have attorneys to represent themselves because they cannot afford counsel, cannot find counsel, or believe that they just don't have any other options. Courts often say self-represented litigants are held to the same standards as attorneys, but are often left out in processes where attorneys are included. But if that is true, then the system should at least provide plain language notice of what exactly is happening. This bill would require a simple notice explaining the purpose of the hearing, what issues may be decided, how exhibits are being submitted, how digital evidence should be indexed, and how to request a continuance, and how to find information about reconsideration or appealing. This is not legal advice, this is not special treatment, this is basic procedural clarity. A person should not lose contact with their children because they did not understand what type of hearing they were walking into. A person should not be silenced because they had evidence but did not know how to label or present it. A court process should not become a maze where only trained professionals can survive. The bill also includes protection against bad faith use. That is important because any accountability system can be abused if safeguards are not built into it. This proposal would allow sanctions for knowingly false filings. It would allow the review unit to decline repetitive, frivolous, or abusive submissions. It would protect confidential victim information, child records, addresses, shelters, and sensitive records. It would also make clear that this process cannot be used to harass, intimidate, retaliate, or force unlawful contact. This reform protects real victims and protects people from false accusations because both of those things matter. Another part of this bill is the creation of a Family Court Evidence Integrity Review Unit, or what I call a Family Court Integrity Safety Valve. This review unit would not be a new court, it would not overturn judges, it would not discipline attorneys, it would not prosecute crimes, it would not decide custody. Its purpose would be to receive verified complaints about evidence integrity concerns, issue preservation notices when appropriate, help explain evidence index procedures, refer attorney misconduct concerns to the Office of Disciplinary Counsel, refer judicial misconduct concerns to the Judicial Conduct Board, and refer credible criminal matters to law enforcement. It would also refer child safety concerns to the proper agencies and collect statewide data. This is important because right now, many people do not know where to go. If they believe an attorney acted improperly, they can file with the Disciplinary Council. If they believe a judge committed misconduct, they can file with the Judicial Conduct Board. If they believe a crime happened, they can contact law enforcement. If they believe a child is unsafe, they can contact Child Protective Services. If they believe the court made a legal error, they may need to appeal. But this is real life, and sometimes these issues often overlap. A parent may be dealing with custody, contempt, PFA enforcement, false reports, ignored evidence, attorney misconduct concerns, child safety concerns, and due process problems all at the same time. That's overwhelming for most people. This is where people fall through the cracks here. Because this bill does not erase existing channels, we are connecting them. Because currently there's no system that connects all these to interoperate and communicate like doctors' offices do on specialty doctors' referral units through medical notes. This would be an interoperable pipeline connecting all of these systems on a unification level. It creates a lawful neutral triage point so serious concerns do not get lost simply because a person does not know which agency handles which issue. Another feature of this reform is annual public reporting, and this is going to be important. The public deserves to know how often these issues arise. Obviously the reports would be anonymized. It would not reveal names, docket numbers, addresses, children's identities, sealed records, or confidential abuse victim information. But it would show patterns. How many evidence preservation requests were made? How many digital evidence indexes were filed? How many referrals went to disciplinary authorities? How many referrals went to judicial conduct authorities? How many cases involved emergency custody review concerns? And what counties may need better training and more resources available? Because you cannot fix what you refuse to measure. And the only way that we can measure anything is by creating a simple metric system. So if we're tracking patterns, we have a metrics to base, resource allocation or training allocation. We can base it off of those metrics. The proposal also calls for training. Judges, attorneys, court staff, domestic violence advocates, law enforcement, self-represented litigants all need clearer education on digital evidence, PFA enforcement, parental alienation allegations, false report allegations, child safety, trauma-informed proceedings, and due process. This is not about blaming one group. It is about modernizing the system for the reality families are living in right now in this time of days. Family court is no longer just paper filings and oral testimony. It is apps, it is videos, it's screenshots, it's voice messages, police body cameras, digital records, phone logs, email chains, location records, and electronic evidence that may make or break a case. The law has to catch up. This reform also proposes starting with a pilot program that makes the bill more realistic. So instead of forcing every county to implement everything immediately, Pennsylvania could launch a 2-year pilot program in the mix of urban, suburban, and rural counties. The state could study what works, what does not, what costs money, what saves time, and what improves outcomes. Then legislators could decide whether to expand it statewide. That is a reasonable approach, I think so. It's not reckless, it's not emotional, it is practical and objective. Now, I want to speak directly about why this matters. When a family court system fails, the damage, it's not abstract. Children suffer, parents suffer, abuse victims suffer, people falsely accused suffer. Good attorneys are undermined by bad actors, good judges are undermined by inconsistent procedures, public confidence collapses, families become trapped in cycles of litigation, fear, retaliation, and confusion. And once a parent-child relationship is damaged, time simply cannot be restored there. It's just, once it's gone, it's gone. A lost month matters. A lost year matters. A child being turned against a parent matters. A protective order being violated matters. A false report matters. A court ignoring evidence matters. An attorney knowingly relying on false testimony matters. A judge failing to create a clear record also matters. These things matter because the court system is not just processing paperwork. It is making decisions about human lives, affecting our day-to-day existence. That is why the standard must be higher, a lot higher, because these back-end deals, these low subbar, ethical, whatever you want to call them, they directly impact people's lives, directly impacts people's ability to be productive in the community and mentally okay. Like, this directly affects our stability and our mental health on a day-to-day basis. It also obstructs our children's right to a stable, happy, healthy, and loving environment. This reform package is not asking Pennsylvania to reinvent justice. It is asking Pennsylvania to strengthen the process we already claim to believe in. Preserve the evidence, clarify the hearing, protect the children, enforce the orders, respect due process. That is a big one being violated right now. Hold bad faith actors accountable, create a neutral safety valve, and build a record that the public can actually trust for a change. Real transparency. That is the heart of this proposal. To any senator, representative, advocate, attorney, judge, parent, or citizen watching this, I'm asking you to consider this reform seriously. Not from the perspective of one case, not from the perspective of one person, but from the perspective of every family that could one day be standing in a courtroom with everything on the line. Everything. If the evidence exists, there should be a way to preserve it. If the court is going to make a life-changing order, there should be clear notice. If a person is representing themselves, they should understand the basic processes. If an attorney knowingly uses false evidence, there should be a referral pathway. If a judge's impartiality is reasonably questioned, there should be a transparent review process. If a protective order is violated, there should be consistent enforcement. If somebody is abusing the court system, there should be consequences. It's only fair. That would be unbiased. And if children are caught in the middle, the system should move with clarity, urgency, and integrity. This is not a partisan issue. This is not a men's issue. This is not a woman's issue. This is not a plaintiff's issue. This is not a defendant's issue. This is a Pennsylvania justice issue. A fair process protects everybody. The Family Court Evidence Integrity and Protective Order Accountability Act is a reasonable step towards making sure that family court decisions are based on evidence, not confusion. Due process, not pressure. Child safety, not manipulation. And accountability, not silence. I'm asking state senators and representatives to review this proposal, improve it, sponsor it, and help create a safer and more accountable family court process for Pennsylvania families. Because when the system works, everybody is protected. Not just the civilian, the state operators as well. It protects everybody on all levels across the board. And it creates a transparency level that works for everybody involved. And when the system fails, everybody pays the price. Because at some point, then you got scandals, you got litigation, you got monetary payouts to families because, courts and people involved just didn't want to do their part, or because they were friends with somebody. It's not biased or impartial in any sense of the word. Thank you for listening. Again, my name is Todd Houseconnect, and I'm asking for this reform to be considered in good faith for the protection of families, children, due process, and the public confidence in the courts once again. Let me know your opinions. Drop it in the comments. Thank you for your time.